Hello, Colorado real estate investors, Colorado tenants. Mark Cunningham with Grace Property Management. So in Colorado, Governor Polis has just signed into effect HB 23-1120. This new bill, this new law, is going to change the way evictions are handled in Colorado, and it's a very complicated law, but we want to take a few minutes and kind of explain the ins and outs of this for both landlords, because it's going to impact you, and tenants in Colorado. Now, the title of the bill is Concerning Eviction Protections for Residential Tenants Who Receive Public Assistance and in Connection Therewith Making an Appropriation. Long title there. The purpose of the bill, really, from the writers of the bill, is to protect tenants who are on public assistance by requiring landlords to engage in pre-eviction mediation with tenants who receive assistance. Now, this is a long bill here. We will link to this if you want to read the actual bill. If you're having trouble sleeping tonight, read through the 8 pages of this bill. It's complicated. It's hard to understand, purposefully so, I think, the way it's written, so that it will slow down the eviction process in a pretty dramatic way. Now, regardless of your position on whether or not landlords are overly focused on evictions or whether tenants are taking advantage of landlords, the facts of the case and the facts of the law are this. Number one, it requires mediation on any eviction unless the landlord shows that the tenant is not on housing assistance. Now, this is any eviction. So number two, every eviction form that is posted or served from a landlord to a tenant must now include a new mediation advisement, basically telling the tenants, hey, we could do mediation if you receive assistance. And this applies to rent and non-rent evictions as well. So if you have a tenant that is having a major lease violation, it doesn't matter what it is. They could be selling drugs out of the back door. You've got to potentially mediate before you can go to your day in court, but only if the tenant receives assistance. So when you're serving the notices to be served are immediately changed. If you had previously served a notice, like in the last week or two, that gets thrown out and you've got to start over to make sure that you're serving the notice, which includes the mediation advisement. Now, mediation is required if the tenant receives any one of these 3 types of public assistance: supplemental security income, Social Security disability insurance, or cash assistance through the Colorado Works program. So if the tenant receives any of these 3 types of assistance, that's when this law kicks in on the mediation side. So whether or not they receive these things or not, you still have to serve the proper paperwork. But then if they receive one of these types of assistance, you must now go through a mediation. So as you're filing your paperwork with the court, so let's pretend the tenant doesn't pay, you serve the information to the tenant, you now must file a signed affidavit with the court with an eviction filing that states one of the two. It's going to either state that the tenant does receive assistance, you mediated, and the mediation was unsuccessful, or this affidavit is going to state that mediation does not apply. Now, operationally, what this means is you as a landlord have to know if your tenant receives one of these 3 types of assistance, and you have to give an affidavit, which is a signed, sworn statement to the courts that the tenant, for example, doesn't receive any of these. Well, how does the landlord know that? Shouldn't this be private, protected information? Well, the law does carve out something to say landlords, even though this is technically private information, in this case, you have the ability to go ask, well, that's good because I have to sign an affidavit as the landlord stating whether or not my tenant receives one of these types of insurance. So we give this affidavit to the court along with the court filing, a signed sworn statement. An affidavit's kind of a big deal. We have to give that to the court system stating whether the tenant receives it, whether we mediated, or whether the mediation does not apply. Now, mediation, so if it does apply, mediation must be conducted by a trained, neutral third party, and it has to be scheduled through the State Office of Dispute Resolution. So there's a mediation section of our state that we have to go through. So when we file it, we have to go through this mediation process now before we can even get our date in court. And of course, the mediation is paid by who? Landlord. Doesn't matter what you write into your lease agreements. So if the tenant doesn't pay rent, you serve these papers, you schedule mediation, landlord pays for mediation to go through that process. That's where we're at right here in this imaginary process. Don't worry, it gets a little bit more complicated, because from there, if the mediation is unsuccessful and you go forward with an eviction, a writ of restitution cannot be executed for 30 days and must be endorsed not prior to 30 days after judgment. Currently in Colorado, it's a 10-day wait period. I believe they passed the 10-day wait period just last legislative session. So meaning, if you go all the way through the court process and you go through a trial, and if you as the landlord, if you win the trial and the judge says, no, Mr. Tenant, you have to move, you had to wait for 10 days before anything could happen, before that judgment could be given to the sheriff to potentially serve. Well, now it's 30 days. So you've already taken, literally this is going to take about 3 months. You've taken 3 months to get through the court system. You win, maybe, and then the win still says you have to wait an additional 30 days before the writ can move forward with restitution. So a couple other little minor pieces about this bill here. Every lease, this is written into the law, every lease must now contain new language regarding source of income discrimination protection, which is already a law in Colorado, but we've got to now make sure that our leases add this new language. This bill is effective immediately. So when they sign bills, when the governor signs bills, they can put in what's called a safety clause, and the safety clause says that, in our opinion, what is happening right now is so egregious, this must be effective immediately. There's no time to delay. It's a safety clause. I don't know if the safety clause truly applies, but it does apply in this bill, so therefore it's effective immediately. Now, this does not apply to landlords with 5 or fewer rental properties. Now, many attorneys aren't going to, for the attorneys we've talked to, they're not going to differentiate how many properties people have. They're just kind of putting this in place for, this is the new eviction process, whether you have 5 or less. So it's a very confusing law. There's a lot more to it than I said right here. But this is the overarching aspect of this law. So a couple final comments here. There are more new laws that just passed as well. In the coming days and weeks, we will dissect those laws for you, explain kind of how you as a landlord or how you as a tenant need to make sure that your landlord is operating under these new sides of things. So if you're a landlord of ours, we're going to be reaching out to you to get some information as it relates to the CARES Act, which we talked about last month. And if you're a tenant of ours, we're going to be reaching out to you to find out if you receive Social Security or disability or Colorado Works program income, because we're required by law now to find that information out from you as a tenant of ours. Now, we don't really give our personal opinions on these bills, and we're a property management company, so we make sure that we abide by the legal requirements. But we will say that we expect this and the other laws to have the exact opposite impact of the purpose. The purpose is to reduce eviction filings in Colorado. We don't see that happening. We've been in business since 1978. We've seen over 45 years many tenants who haven't paid rent or who have trouble paying rent. And what is typically done in the industry, if a tenant says, gosh, I have to pay late, landlords, most landlords, not all landlords, but most landlords will work with the tenant in those situations. They will accept a partial payment, schedule a later date to pay another partial. They'll stretch out the payment period. What's happening with these laws is that it makes the eviction process so long and so drawn out that landlords now, on the very front end, if a tenant says, I can't pay or I'm going to pay late, the landlord is going to immediately initiate the eviction process because it's going to take so long. Before this stuff was happening, and when eviction time frames were shorter, what landlords would do is say, oh, if you can't pay all of it right now, that's fine. Give me some now, give me some later, and I won't file an eviction, knowing that if the tenant didn't come through with the payment plan, the landlord then could file an eviction, and that would move rather expediently through the process. Well, there's no more expediency in the eviction process. It's the exact opposite of that. It's going to take months and months and months. So now what's going to happen is on the very front end, the tenant says, I can't pay all of it right now. Landlords are going to immediately file an eviction because they have to get the clock ticking on this months and months and months wait time to get an eviction. That's just the reality of how this is going to play out. So I really believe what we'll see is an increased filing from landlords against tenants on eviction. Landlords would rather not, believe me, landlords would rather not file an eviction, but if they have to have a months and months and months waiting period, they're going to file on the front end to try to reduce the likelihood of the tenant staying any longer. Not great news for tenants, we believe. Not great news for landlords, we believe, but that's the reality of where we're at right now. Now, if you're a current owner-client of Grace Property Management, don't worry. We've got all this covered. We're making sure that we abide by these current laws, that we're getting the information we need from tenants, from owners. If you're not a current client, owner-client of Grace Property Management, and we can be a resource for you, or if you need assistance in the management of your Denver rental property, we're happy to help both tenants and landlords. We believe that when tenants and landlords are treated fairly and equally, it's truly a win-win for all the parties. That's how we operate. That's how we will continue to operate. So know that as a landlord, we'll represent you. As a tenant, we will treat you very, very fairly. Jump on our website, rentgrace.com, if we can provide any assistance for you.